Hello, I hope you're doing well. My name is Zach Persing, and I am a second-year law student at the University of Pennsylvania. Today, I have the great pleasure of speaking with you about the Supreme Court case, New York Times v. United States. This was a case that the Supreme Court heard in the year 1971. Now, this is a First Amendment case, but before I get into the relevant law, I want to just start with the facts, because I think that's really what's crucial here. And if we understand the facts, I think that the law is going to be more meaningful and relevant. So, as you may or may not know, the Vietnam War was a very controversial war from the perspective of American involvement in the conflict. While there were many Americans who supported U.S. involvement in Vietnam, there was also a very large number of individuals who very vocally opposed U.S. involvement. And that group was very loud and organized. There were oftentimes anti-war demonstrations and protests. So this was a very controversial conflict at home in the United States in terms of evaluating the country's involvement. It was not a war where the country was united in supporting the effort. It was very much controversial with people on both sides of that question. So in the year 1967, Robert McNamara, who was the Secretary of Defense at the time, commissioned a secret study on the U.S. involvement in Vietnam. Now, this study eventually came to be known as the Pentagon Papers. And in the production of the Pentagon Papers, a man by the name of Daniel Ellsberg came into contact with them. He saw them. And that is because he worked for the RAND Corporation, which was one of the entities involved in producing this secret report as directed by Secretary McNamara. Now, Mr. Ellsberg formerly supported the war effort, but he changed his opinion and eventually became an opponent of the war. He did not support American involvement in the conflict. And when he saw these papers, the Pentagon Papers, it was his opinion that if these papers became public, many people who supported the war could have a similar conversion like he did and become opponents of the war. They wouldn't support it because he felt that these papers painted the American war effort in a negative light. And again, if they became public, it would sway opinion against the war. So Ellsberg initially advocated for these papers to be released through official channels, but the United States government, specifically the Department of Defense, I presume, was having none of that. His efforts to publish these through the government failed. So at that point, Mr. Ellsberg made a very consequential decision, and he decided to leak the papers to the New York Times. Now, it's important to note he didn't leak all of the papers. He leaked most of it. He held a little bit back because I think he was concerned that it would potentially endanger lives or undermine the government unnecessarily in the event that that part of the report was published. But we should know that most of the report was published. It wasn't just the select few parts of the report, it was most of the report. So the New York Times, they're not sure what to do about this because the United States, they're still involved in the region, and they're still involved in the conflict, and there's a real question about the journalistic ethics of publishing these. These were leaked illegally, and the publishing of these documents would also presumably undermine, or at least have the potential to undermine, the war effort, the United States war effort in Vietnam. Is that something that the New York Times wants to be involved in? Well, after several months of internal debate and discussion, they ended up deciding that they wanted to go forward and do it. And they announced the plan to publish these papers in a series of 9 installments. After the 3rd installment, the Nixon administration, again, that's President Richard Nixon, they filed a lawsuit seeking a restraining order that would force the New York Times to stop publishing the Pentagon Papers. And what the Nixon administration argued is that publishing of these documents was a threat to national security, which, whether or not you think that justifies stopping the publishing of the papers, that at least strikes me as a non-trivial argument. I mean, they were publishing documents that had to do with the American military and America's war efforts. So it's not hard to see how that could at least possibly undermine national security. But at the same time, the New York Times had a very compelling argument in the First Amendment, which I'm going to read to you right here. And may I also point out, it is always good to have a copy of the U.S. Constitution with you. I always do. You never know when it's going to come in handy, but it often does. So the First Amendment reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people to peaceably to assemble and to petition the government for a redress of grievances. So this case squarely implicates the freedom of the press. Now, the question here is whether or not the freedom of the press, which is clearly implicated, can be overridden by a national security interest. The district court in this case says yes, and they grant a restraining order, meaning the New York Times cannot publish these papers anymore. So what does the New York Times do? They appeal the decision to the Second Circuit Court of Appeals, which affirmed the restraining order. So the New York Times was still in a position where they could not publish these documents because of the court order. So at this point, two important things happen. The New York Times seeks an appeal with the Supreme Court, and Ellsberg then leaks the papers to the Washington Post because it didn't look like the New York Times would be posting them, be able to publish them anytime soon. So the Washington Post begins publishing, and the Supreme Court not only agreed to take the case from the Second Circuit, but they agreed to hear it at the very next day, which is highly, highly, highly unusual. And at the same time this happened, the Nixon administration sought injunctive relief against the Washington Post because they were now publishing. They were not successful in that case, but then these two cases were combined before the Supreme Court. They were consolidated, heard together as one before the Supreme Court. Oral arguments were heard on January 26th, 1971, and then the court issued a decision, again, highly unusual, just 4 days later on June 30th, 1971. So from beginning to end, this legal process only took 15 days, which is just extraordinarily unusual. Oftentimes, a legal process like this can take years and years and years. And while I'm not going to tell you what the court actually did in the case, because I don't want to spoil it, I do want to say that there were some justices on the court who argued that the Supreme Court shouldn't have even taken the case because it's inappropriate for the court to hear a case that came up to it so quickly. And that is because the Supreme Court, generally speaking, is an appellate court. And the way the Supreme Court works is ordinarily before a case gets to the Supreme Court, it has gone through potentially years of litigation through either the state court system or the federal court system. And what that means is that a very significant and lengthy record, a legal record and a factual record, has been developed in time before the case gets to the Supreme Court. And such a robust record allows the court to really have as much information as possible at its disposal when it makes a decision about the case. And the reason why that's really important is because Supreme Court law, it's law not just for the two parties that are before the court, but it's binding precedent. It's law for the rest of the country. So what the Supreme Court does is very important, and it has real consequences beyond the two or however many parties are before the court. So it's really important that the Supreme Court makes good law. So really, the two things that I would encourage you to think about when you talk about this case is, number one, this issue of whether or not the Supreme Court should have even intervened so quickly, whether that was the benefits of that outweighed the cons or vice versa. And then really the substantive legal issue, is the First Amendment freedom of the press an absolute right? And if it's not an absolute right, can that be, in what circumstances can it be overridden? And the other thing I would encourage you here to think about is it arguable that the power to block publication of these papers falls within the president's constitutional obligation as commander-in-chief? And if that's so, how does a court resolve a situation where two parts of the Constitution come in conflict with each other? In this case, theoretically, that would be the First Amendment and the president's obligation to be the commander-in-chief. So again, these are very interesting legal questions. But again, I want us to think about two things here, both the process and the substantive law. Thank you so much. I really enjoyed the opportunity to speak with you about such an interesting and wonderful case. And remember, keep that pocket constitution on you because you never know when it's going to come in handy. Take care. Thank you so much and have a great day. Goodbye.